And if I may kindly just bring the case of or a reminder here of the most recent Darfur, and I'm going to call it genocide myself, but remember how much of controversy is actually existing about it. And for that matter, you had Prosecutor Ocampo that brought up charges against President al-Bashir on genocide, but they were not replicated by the trial chamber, by the pre-trial chamber, I should say. So that tells us that there is a sort of difficulty in there in terms of really proving it. And then we come to the question, what about crimes against humanity? How much of a difference really is between these two crimes in terms of the notions that they represent, and also in terms of the punishments that the international community has come up with for certain crimes? You probably know that in the international criminal courts there is no death penalty, and crimes against humanity do also get the highest punishment possible. And if we look carefully at the characterization of crimes against humanity in Article 7 of the International Criminal Court Statute, you see that there are numerous acts that are acts that I can fairly and squarely see in each and every one of them, acts that have already happened in Bangladesh. And they are not at all of any lesser demeanor or stigma that genocide has. So what I would say, seeing this overall reluctance of the community to necessarily name acts a certain way, what is really important is justice. So that this justice that has been delayed for so long does not really become justice denied, ultimately. Then, which way and what courts? If I understood correctly from the government representative this morning, it seems that the Bangladeshi government has taken upon itself to pursue prosecution of atrocities of the 1971, and rightly so. I think it really, in my view, that should have happened long time ago. But also we understand very well that there are both subjective and objective reasons for something necessarily not happening. And particularly when you talk about states whose right to self-determination is there and tries to be violated at a point, bringing about really massively and indiscriminately atrocities, as the case of Bangladesh is, there is always this quest for the newly independent state to gain recognition. And sometimes you just have to give something or delay something for what you consider a purpose that is more important on your agenda item. However, as Professor Bhatt mentioned, it is of course for the Bangladeshis to decide which way they want to pursue. And maybe the 1973 Act is a good one, but maybe it really does need a lot of revision as well, particularly nowadays, if we're going to talk in light of all the standards that have already reached a consensus in the international community. We are not back in 1971 or in 1973. Bad as it is that justice has been delayed, if we want to look at the silver lining, we have gained a lot of, we, the international community, all of us, have gained a lot of experience in prosecuting these crimes and sort of have a better roadmap which way to go. Maybe it is not a bad idea at all to look for a hybrid tribunal. Maybe not necessarily a bad idea. You have to think about in so many matters that could be involved. Finances would be just one, having the overall help, but above all, justice that not only has to be fair, which we do not doubt, and rightly so. Somebody mentioned this morning, a Bangladeshi mentioned that we have nothing to hide, so we invite everyone to see everything. That's plain and clear, but at the same time, there is also the idea that justice and fairness has also the necessity to be seen as doing right. So even appearances of any lack of fairness whatsoever, or let's say independence or impartiality or competency of judges, even if any of these issues ever comes to play, that would absolutely not be any good at all, I would say, for a democratic country like Bangladesh that is so vehemently and should pursue persecution of these atrocities.
Well, I think there's a consensus about charging or releasing and proceeding with a trial. I think there's still open questions as to whether this should be done through a military tribunal and whether it should be done through the ordinary courts or through special courts. I think that's an issue. I also think that there's an issue, I wonder whether, let me put it this way, I wonder whether there isn't also an issue with respect to the time-boundness of the statute. We haven't had an international experience in the administration of criminal justice since the 40s, during the Cold War. Which, as we come out of the Cold War, we go into the unraveling of the former Yugoslavia. We have Rwanda, so we have the two ad hoc tribunals which sit with respect to that. Out of that, we begin to crystallize decision-making with respect to what is genocide. Okay? So I'm wondering whether or not, and I haven't done my homework, I must tell you in this respect. My sense is, just off the top of my head, that the 73 Act is really a replication of the London Charter. So it's what Nuremberg was charged with, and Nuremberg did in fact not, according to some of us at least, Professor Wiesner, for example, did not in fact do justice to the London Charter and collapsed crimes against humanity as a separate offence into war crimes, okay? So I wonder whether or not it isn't a very good idea for the diaspora, the Bangladeshi diaspora, to say, look, we have all this knowledge now, dust off this act, and instead of keeping it in the old terms, look at the ICC, the Statute of Rome, and look at the way in which now genocide, crimes against humanity, and war crimes has been defined, it's been redefined to some extent. We have a better understanding of this. It's time that we put this new knowledge into play. Now, I'm worried in saying that, Professor Clark has come and said, it's got to be 1970.
Sure. Look, you've got to apply the law as it was in 1973. The whole theory behind this is we're setting up a tribunal with jurisdiction over existing crimes. That was the theory at Nuremberg. One can argue about whether it was true about crimes against peace or whether it was true about crimes against humanity. It was certainly true about the war crimes material at Nuremberg, which is essentially the Hague Conventions of 1907. But let me just answer the bit about genocide and come back to the 1973 statute. Because whatever you make of genocide, it was defined by treaty in 1948. And the 1998, 50 years later, Rome Statute of the International Criminal Court defines it exactly the same way. There hasn't been any movement on the legal movement of genocide in that period. And it's for that reason, I would submit, that the definition in the 1973 statute just doesn't make it. Because you'll notice they have a list of grounds upon which you do these things to people, such as national, ethnic, racial, religious, and then they sneak in or political. Now, Adam Jones mentioned the political side of a genocide in his presentation earlier on. Political was a word that was in the draft which went to the United Nations General Assembly in 1948, and it got taken out. Think about the situation in 1948, that the Soviet Union had a gulag which took people off on political grounds. They weren't going to agree to do this. All sorts of colonial powers, the French and others, were doing ugly things on political and cultural grounds. They didn't want the word political in there. It disappeared. Similarly, in the drafts that we considered for the International Criminal Court in 1997, the word political had been put in, and some, particularly small countries, tried to get that in and amend the definition. Was the response. Genocide is well established, and we